Hello and welcome to episode 2 of the MedTech podcast. You join me, your host, Karandeep Singh Badwal, and in today's episode I'll be hosting Stephen Carter, who is a patent attorney and the founder of Intellectual Property Works. He has worked for many top businesses and is now recognised as one of the world's leading IP strategists. On this episode, he shares with us his journey and why he now focuses within MedTech startups and the common misconceptions people often have about IP. Stephen, welcome to the show. How are you today?
Yeah, I'm very well, thanks, Karandeep. Great to see you.
So, Stephen, what exactly is intellectual property, and what are the common misconceptions people often have about it?
It's a great question, and I think one of the issues around intellectual property is that there's a kind of a misunderstanding of what it is and how it's relevant to businesses. And when people hear intellectual property, they often think patents are often the first thing they think about. But intellectual property is much broader than that. And I like to think about it in sort of two different layers. So you have intellectual property itself, which is it's the fruits of your innovation. It's the stuff that you're creating. Typically, it's the thing that differentiates your business from your competitors. It's the thing that makes you unique. It's the thing that you're investing in. And basically, if you're a business and you're innovating, then you are generating intellectual property. So that might be, it might be invention. So it might be technical innovation, but it could equally be softer forms of innovation. So it might be software code that's being written for you or that you're writing. It might be a new brand that you're developing. It might be business processes that you're creating to deliver your coaching course. So it's really anything that you're creating with your own mind, or that you're paying other people to create with their own mind, that supports your business and the services you're delivering to your clients. So that's if you like the kind of underlying IP assets. And then layered on top of that, you have the intellectual property protection. So that's the legal mechanisms that exist to give protection to those underlying IP assets. So, in the case where the underlying IP asset is, say, an invention, so technical innovation, patents are one of the intellectual property rights that you can use to protect that. But you might also use trade secrets. So simply keeping something secret can be, in some cases, a really powerful way of protecting an innovation, whether it's technical or business process. And a great example of that always gets cited is the Coca-Cola recipe, or the Colonel Sanders Kentucky Fried Chicken recipe. And so that's so patents is an example of an intellectual property right. Trade secret is an example of an intellectual property right. Registered trademarks, copyright. So there's a whole suite of these intellectual property rights, legal rights, that you can use to protect the innovation that's going on in your business. And I guess typically what you find is that when you look at any particular innovation within a business, it's not just one intellectual property asset that's being created, and it's not one intellectual property right that's going to be relevant. There might be multiple assets around. So if you're developing a new product, there could be there's going to be some technical innovation there. There's going to be probably a brand associated with that. There's going to be a lot of know-how around the product. There might be software code that's involved in the product. So you end up with this collection of IP assets that underpin the value in the product, and then you can use a mosaic of intellectual property rights to protect it.
Okay, so Stephen, if you go right back to the start, how exactly did you get into intellectual property? Was that always your intention? And the second question from that is, then why did you then go on to specialize within MedTech?
But it may not surprise you to hear that I didn't grow up dreaming of being a patent attorney. And to be honest, it's not a profession I'd even come across until I was coming towards the end of my undergraduate degree. And I guess I grew up, doing the normal things of probably wanting to be an astronaut and a fireman and those type of things. But actually, when I really started thinking about what I wanted to do, I was fairly certain I wanted to become an engineer. I used to love, and still do love, understanding how things work, finding out how they work. I used to take cars apart and put them back together with my father. My granddad was an engineer. I used to love the stories he would tell about the projects he was working on. So kind of engineering was going to be my thing. And I went to Bath Uni, did an engineering, mechanical engineering degree there. And then wasn't quite sure what I wanted to do as I was coming up towards graduation. And so stayed on and did a master's, sort of a research master's. So again, it was engineering, but it was more software related. And then as I was coming towards the end of that, I kind of realized, well, I've got to go out into the big wide world now and find something that I want to do. And it was actually with the help of the careers office at Bath Uni, basically stumbled across the profession of patent attorney. Went and spent a day with a firm of patent attorneys based in the centre of Bath, and I was going to say fell in love with it. It just really appealed to me because I had a great combination of that ability to you had to get into the detail of the technology. You had to understand what it was, how it worked. You had to have the skills to describe it, but you also had the challenge of the legal framework you then had to fit it into. So there's a lot of sort of problem solving and some more learning around the legals. So anyway, so I kind of jumped in both feet to that, and haven't looked back since. So 26 years later, still really enjoying it. Where we get so the second part of that question was why MedTech. So I guess over those 25 years, I've worked across a variety of different technologies, and again, as you can imagine, like early in your career, you don't have very much choice about what you're working on. You're working on whatever your boss tells you to work on. But I was fortunate that quite a lot of that work ended up being in the medical device and the MedTech field more generally, and I kind of, I guess, recognised as I was getting further through my career that was the stuff that I enjoyed most. And I think it's something around they're inventions that you're helping people protect that are making a real difference in the world. There's a couple of examples where I got to sort of not experience firsthand, but I got to see the real impact that the inventions I was working on were having. So there was one case I remember particularly well where I was handling an appeal at the European Patent Office, and it was in an opposition case. So we had basically someone else was attacking the validity of my client's patent, and it was for a video laryngoscope. And part of the evidence we were submitting there was evidence from doctors who'd been using this, and also video evidence showing the difference between using a traditional laryngoscope and this new video laryngoscope, and just the massive improvements in terms of the ability of the physicians to use this device compared with the traditional device. It just brings home the impact of it. And the other, so as another client, I did an awful lot of work for in the past, a company called Second Sight, who West Coast US based company, but they developed a retinal implant for restoring some form of vision to people with a retina that's deteriorated. And again, I had the opportunity to see some of the sort of interviews with some of the patients who had that implant. And I must admit, you see in the patent application, you'd see diagrams of the sort of sight that was restored, and it's very low resolution, and you think, well, it's not that, it's maybe not that great, but actually you hear the stories from these people, and then there's one elderly gentleman who was telling a story about how he can now effectively see the outline of his grandchildren stood in front of him. And another person telling a story about how they can now walk down the street without worrying about hitting their head on a low-hanging branch, because they can make out enough to be able to see it. So yeah, so just it gives you a buzz when you're helping businesses who are developing that new tech succeed, because if they can protect their intellectual property, then that helps them get investment. It helps them get the funds to continue the development and bring those sort of products to market. So
yeah, I completely agree with you on that one. The satisfying part of your work is actually seeing the devices out on the market, actually helping people. Because like you said, even in quality and reg, what I do, I'm sitting there with tons and tons of paperwork. I'm seeing pictures of devices, I'm seeing development plans, risk assessments, but it's only sort of hits home when that device actually hits the market. And you're seeing things like patient testimonials, you're having physicians coming back to you about how it's changing patients' lives. And that sort of makes the work worthwhile. All the stressful times that you had, the extra hours that you put in, is that sense of satisfaction you get. So, I mean, going on from that really is, would you agree that IP is often misunderstood in MedTech? And how do you go about selling that service about IP? Because unlike quality and regulatory, which is actually essential to get your device on the market, with IP, it's almost like driving with no insurance. As long as nothing happens, you'll be fine. But really, you should have that insurance in place. So how do you go about overcoming that challenge?
Yeah, no, that's a really good analogy. Actually, I do quite like. I quite like that. I might steal it from me, but although it's your IP, but you're right. I think it is misunderstood. I think there's, I guess, particularly for the smaller businesses, I think a lot of smaller businesses, they have some appreciation for intellectual property being important, but because they don't fully understand it, it's always something they're worried about tomorrow, or they think something that once we get some more funding, we'll then focus on our IP. And I think some of that misunderstanding comes from one of the things I touched on earlier, which is that when people think about IP, they think about patents. They think that means it's really expensive, and a lot of the smaller companies then dismiss it as something that they can't afford at the minute and they'll worry about later. And I think, and if I'm honest about it, I think there's a sort of that misconception is driven by investor views sometimes as well, because when small businesses are talking to investors, there's a real emphasis on patents. So there's that focus on patents, and people think IP means patents, which means lots of money. But actually, I think there's an awful lot that smaller businesses can do right from day one. I kind of think about it as building the foundations. So if right from day one you have a mindset where you have the right understanding, the right approach to intellectual property, and as an example, I kind of talk about one of the foundations of IP when I'm talking to my clients about being ownership, and it's something that in the investment deals I've been involved in, looking at the due diligence, is one of the things that in my experience goes wrong most often. And it's sort of so easy to get right if you just focus on it at the outset. So when someone's doing some innovation, the starting point is that they own the bit of IP that they're creating. Now, if they're employed by someone to be creating stuff, then the chances are their employer will own that. But what you see in smaller businesses is a lot of, you necessarily have a lot of outside help. So you might be working with an academic institution and benefiting from some of their research. You might be working with a development house who are doing some of the design work for the device that you're developing. You might be working with a software house who are writing the software code. And if you don't have the right agreements in place with those other parties that are involved, then you can find yourself down the line when you're looking to raise money in a situation where you don't actually own the intellectual property in the innovation that you're supposedly building your business on, because the lawyers dig into the detail and they find out that actually the university still owns some of those rights, or the software house still owns the copyright in the software code that underpins your product that you're going to be launching. And yes, often you can sort it out at that point if the parties are all friendly and talking to one another. But it's a headache, and it's a headache at a time you don't want it, because you're in the middle of trying to raise money and you're focused on that, and this is suddenly distracting you, and you're having to run around and put plasters over things that actually, if you'd worked it through in the first place, you just wouldn't be in that situation. And
Okay,
that's
so the
sorry,
advice that you'll give from that, would it be that they should think with IP at the start to prevent problems in the future?
yeah, I think I've sort of got this. One of my mantras is about putting IP at the heart of your business, and I think a lot of it is just recognizing as a small business that when you're innovating, you're creating IP, as I said earlier, and that's valuable, and you need to look after it. And it doesn't cost you anything to make sure that when you're negotiating those agreements with suppliers, you think about IP and you make sure the IP clauses are in there. It doesn't cost you any more than it would cost you when you were negotiating these agreements anyway. And keep a simple register of the IP assets that are being created. Keep good records around who's creating what when. These sort of simple, inexpensive steps that every small business can take. It really just puts those foundations in place to build on when you do have the funds to then protect.
So when it comes to protection of IP, how does it work on an international level? Of course, with quality and regulatory, we'd have one submission for EU, one for the UK. Now, because of Brexit, we'll have another one for the USA. How does it work with IP? Is there an international database? Is it something that you need to do individually with countries? How would a company go about dealing with that?
So yeah, I mean, sort of similarly to the regulatory field, intellectual property rights are national rights or geographically bounded rights. There's two, I guess we're sort of stepping back a minute and just saying there's two main categories of intellectual property rights. So there's the registered rights. So that's things like patents, registered trademarks, registered designs, or design patents as they're called in the States, where there's an application process. You have to take positive action to secure that right. And then there's unregistered rights. So that's things like copyright, design rights, the sort of related rights like that, where they come into existence automatically. And for those unregistered rights, because there's no application process, the rights are still national, but you tend to get corresponding rights in other countries automatically as well. It's sort of based on international treaties. But with the registered rights, which are the stronger monopoly rights, you have to file applications in the geographies that you want to get protection in. There's no such thing as a worldwide patent, but there are international agreements that make that easier to do, and that means you don't have to file all of your applications in all of the countries you're interested in on day one. So if we take patents as an example, the normal approach that companies will take, even larger companies, is they typically file in their home country in the first instance. So for most of the businesses I'm working with, that's filing a UK patent application in the first instance. And that sets running a 12-month clock. And so long as you file in other countries before that 12-month clock runs out, then the applications in those other countries can claim back to the date of your first application. And that's important because it's at the date of that first application that the validity of your invention is assessed. So it's let's look at everything that's already in the public domain before you file your patent application, and it's that body of literature that the novelty, the newness, and the inventiveness of your creation is going to be judged. And then even at the 12-month stage, again, rather than having to go, right, I want to file in these 5-6 countries now, you can file something called an international patent application. And without getting into too much of the detail, that effectively buys you another 18 months beyond that. So 2.5 years from your first application in the UK before you're having to make final decisions about countries to protect in. And clearly, as you'd imagine, the number of countries that you decide to go for in terms of protection impacts the cost massively. So the cost multiplies up by the number of countries that you're going to go for protection in. And so, particularly as a smaller business where budgets might be restricted, you have to be quite clever about where you seek that protection. Even large countries won't file in 10s or 20s of countries around the world, and typically you can focus on countries where either your competitors are based, or most often actually just where there are large markets. So, for a lot of MedTech businesses, they'll focus on UK, Europe, US. And actually, if you can give yourself an advantage, some kind of exclusivity in those jurisdictions, then you can have a profitable business. And actually, it can be quite difficult for your competition to cost effectively develop and launch their own product, because if those big markets are blocked to them, and they're left with the smaller markets, it's trickier for them to have a product that's economically viable.
Okay, so when it comes to patents, for example, what would you say is the strangest request or the strangest type of patent that you've had to file in the past?
I've had quite a few fun ones over the years. I remember one of the very first patent applications that I had to write was so I was working in the London office of the firm I was with at the time, and this guy pretty much just knocked on the door of the office, and as one of the more junior members, I got asked to talk to him, and it turned out he was a Turkish barber, and he'd come up with a new invention to do with curling hair and perming hair. So it's kind of sort of new rollers. So that was not what I was expecting, but quite interesting. I was involved in a court case again fairly early in my career. It was all to do with a knife for cutting kebabs. That was a spat between two brothers who were arguing over who had invented the knife. What else? There was another one. I mean, one that sticks in my mind was another court action, actually. So this was one where we were representing the patent owner in an infringement action, but it was to do with muck spreaders. And I still to this day remember stood in a field in, I think it's Warwickshire somewhere, having to run quite quickly to avoid the muck that was being flung out the back of this thing as it went by. So yeah, and I guess one of the clients I've had a lot of fun with over the years is a company called Pentland, who some people will know, some people won't, but they own a number of sort of outdoor and sporting type brands. So they own Speedo, Berghaus, Mitre, and so I actually used to do all of the patent and design work on the Speedo innovations. So I used to leave people with the memory of me being the Speedo wearing patent attorney for a number of years at networking events, which I don't know whether it's an image people wanted to have in their minds, but anyway, it was something memorable.
Yes, the way you've described it is IP is a lot more interesting than people actually think it is. You're not sitting in an office every day, 9 to 5, just dealing with paperwork. There's going to be some days you're doing that, but it seems like you do get around and you get to see quite a diverse types of products out there. So there's a lot more interesting than people think. So Stephen, we've talked about your career, we've talked about MedTech. You mentioned that, you was had sort of a slightly engineering background, you used to work with your family, working on cars. So what do you get up to outside of work then?
So I guess, a lot of it now is spending time with the family. And it's one of the reasons. So this I've got my own consultancy business now that is just over 3 years old. And one of the reasons for taking the jump out of central London law firm to my own consultancy business was to give more time to spend, more time to spend with the family. So I guess, and like a lot of parents with school age kids, as you went to my eldest is at university now, weekends are often taxi service to different sporting events. I try and stay fit myself. So I do quite a lot of CrossFit, which one of my sons does as well, and my wife. So it's again an opportunity to spend time with them, doing something to keep fit. And then I guess the other sort of big passion for me in my life is rugby. So used to play, not particularly well, but used to play quite a lot. Most recently for my local vets side, but that got to the point where it was taking me longer to mend between the matches than there was time to mend. So I kind of hung on my boots, but still quite heavily involved in the local rugby club. So I coached for about 16 or 17 years, and I've just taken over as treasurer there. So that's that's kind of another challenge, but interesting, looking at how we're going to grow the club going forwards, and we'll also kind of ride the roller coaster of being a Bath rugby fan. They seem to, well, it's definitely a roller coaster ride. They do really well one week or one season, and not so well the next. But yeah, still really enjoy that.
Okay, so Stephen, also just like myself, I've seen that you've started to do content on LinkedIn. You've started to do events. What is the future for you? Obviously, you've started your consultancy business. It looks like you're doing a lot of work to get content online, a lot of exposure. What's your plan going forward with this?
It's funny. So I guess, like I said just a minute ago, that one of the main driver for starting this new business, or this kind of changing approach, was lifestyle driven for me. But actually, over the last 3 years, I've recognised that there's a real need in the marketplace for people who can, I guess, effectively be sort of very part-time in-house IP support for smaller businesses. So for me, part of the future, the sort of short-term future, is spreading the word about that, getting smaller businesses to understand that IP is important, and helping them understand what they can, the little baby steps they can take to do that. And then for me personally, building a business around that, and potentially bringing in other consultants who can deliver that same level of service. So being the part-time in-house IP guys and girls, working with these smaller, exciting businesses, which I think works well for those businesses, because they get that expert advice, they get to put the right foundations in place, but they can control the budgets to a degree, and it works really well for people like me, because I think it's exciting work, it's interesting, and you get to really feel you're making a difference to those small businesses.
Okay. So Stephen, thank you very much for coming on today. I like that you've shared advice, we've gone into your story, and question I'm going to ask you now is, what one piece of advice would you leave for the listeners today?
One piece of advice. I think that for me, the main thing is for everyone to just remember that if you're innovating, you're creating IP, so don't ignore it. That's the main thing. I think, because once you have that recognition that it is relevant to your business and you ought to be nurturing it, it means you start asking the right questions, and having the right mindset to think about capturing that value that you're creating, and helping your business succeed. Okay.
So Stephen, if people want to connect with you or learn more about you, where is the best place to reach you?
So as you mentioned earlier, I'm quite active on LinkedIn. So LinkedIn is, you can reach out to me through LinkedIn. That's probably the best place.
Okay, that's fine. In the description below, I'll leave a link to your profile for your LinkedIn and your website as well. But thanks again for coming on, Stephen, and I hope to have you again at some point in the future.
Yeah, no, thanks, Karen. It's been fun.
Right.
Thank you for listening to the second episode of the MedTech podcast. If you've not already done so, please subscribe. If you are interested in learning more about Stephen, you can connect with him on LinkedIn or visit his website at theintellectualpropertyworks.co.uk. If you have any other topics you'd like me to discuss in future, or any guest in particular you want me to bring onto the podcast, then feel free to also reach out to me.